My name's Louis Goodman. I'm a criminal defense attorney in Alameda County, California. I'd like to talk to you a little bit about driving under the influence of marijuana and the problems that come to the prosecutor in terms of proving one of these cases. Despite all the hand-wringing about driving under the influence of marijuana in this brave new world of legalized pot, I don't think much is going to change in terms of the way these cases are handled by the police or law enforcement. As a longtime criminal defense attorney and as a former prosecutor who's handled thousands of DUI cases, I note that there's a really substantial difference between driving under the influence of marijuana cases and driving under the influence of alcohol cases. Marijuana simply does not affect one's ability to drive as seriously as alcohol negatively affects one's ability to drive. Most DUI alcohol cases are found because the police notice some really bad driving. Most DUI marijuana cases are found out because the police make a stop for some other minor infraction. And therefore, they then smell marijuana at a routine traffic stop. So despite legalization, incidents of marijuana arrests will not significantly increase. I mean, let's not kid ourselves. People have not in the past been much deterred by the fact that marijuana was illegal, and due to legalized marijuana in the medical world, there's been a glut of good, high-quality, THC-laden pot available to virtually anyone who wants it. Therefore, legalization is unlikely to affect the number of people who are smoking marijuana, the quality of the marijuana that's being smoked, or the number of people who choose to drive while under the influence of marijuana. For a prosecutor to actually win a DUI case, she must prove to a jury that the substance that the person is using actually has a substantial negative effect on the driving, that it significantly impairs someone's ability to drive. Now, in the alcohol DUI world, we have the 0.08 blood alcohol level that has been established through years of scientific research. All the prosecutor really needs to do is prove that the blood alcohol level was 0.08 or higher, criminal conviction. There is no such standard that has been established for marijuana. So therefore, the case in the marijuana situation needs to be proved by circumstantial evidence. In other words, the circumstances surrounding the driving. Was there bad driving? Was there an accident? Was there a lot of marijuana smoke? Was there a lot of marijuana? And this is a much harder standard for the prosecution to prove. It's not that it's an impossible standard, but given that it's far more difficult than simply proving a 0.08, the prosecutor has an uphill battle. And add to that the generally friendly to marijuana use Bay Area juries, and it's not hard to see why a prosecutor will have some problems in proving a DUI marijuana case beyond a reasonable doubt to a jury. The reality is that legalization, in my view, will only cause a marginal increase in marijuana use, a minor increase in driving under the influence of marijuana, and very little change in terms of police enforcement or prosecutorial attitudes towards DUI marijuana cases. So if you or someone you know has any sort of a legal problem involving a marijuana violation, including DUI marijuana, please give me a call.